Hello, everyone. Right now it's like 1 o'clock, actually 1:28 my time. Welcome to my channel. Welcome to Coffee with Carlene. Today we're gonna react to. I'm gonna give you my reaction on the case of Johnny Depp. Um, it's a video of Johnny Depp attorney outrage and Amber Heard is the abuser scammed him out of $7 million. So we're gonna react. You guys gonna see my reaction. Okay, so let's start. See if I can make it bigger. There you go. Let's see if I can go like this. Okay, so we're gonna do it like this. All right, let's see.
Approach.
All right. Thank you.
Thank you, Ron. I've just handed to Mr. Rottenborn and Your Honor an opposition that we prepared before we had the benefit of seeing Ms. Heard's affirmative motion to strike, but I think we've anticipated the arguments made.
Oh, it's about to get good. I've watched the case so far, and I feel like not all of it, but I'm just catching up. I feel like Johnny's legal team is very good, and I feel like Amber Heard's legal team sucks. Okay, let's get back to the video.
Such as they are. The court should deny defendant Amber Heard's motion to strike because Mr. Depp has come forward in his case in chief with multiple credible witnesses, documents, and authentic tape recordings of Ms. Heard herself, not only satisfying all of the requisite elements of his claim for defamation, including actual malice, but also going the extra mile of showing that Ms. Heard physically abused him.
He said what he said. She was the abuser, and he has receipts. Okay, let's go. The way he's like, I was like, damn. That's the kind of lawyer that I want. Shoot.
He's the abuser in this courtroom. Your Honor, going back to the standard, as Your Honor is well aware, in considering a motion to strike, the trial court must view the evidence and all reasonable inferences drawn from the evidence in the light most favorable to the plaintiff. Any reasonable doubt as to whether the plaintiff has produced sufficient evidence of the wrong alleged must be resolved in the plaintiff's favor and the motion to strike denied, unquote. And that's the Boeing case, I believe Mr. Rottenborn referred to, 243 Virginia 81 at 81, 1992. Quote, the weight and credibility of the...
You see how Johnny is so relaxed? Like he's so confident. And I don't know, I just feel like he's going to win. And I feel like Amber is going to lose because she doesn't have a lot of evidence at all. Like, she's a liar, and they've proven her that she's a liar. Let's go ahead.
Testimony of witnesses are solely matters for the jury. The jury may accept that part of the testimony it believes and reject that which it does not. It is also within the exclusive province of the jury to draw any reasonable inferences from the evidence before it, citing Rate versus Minix, 275 Virginia 579 at 585.
Okay.
In deference and respect to the court's time.
You know, when he take off his glasses, he's ready to read, honey. He's ready to read. I don't know what you guys think. Are you team Amber? Are you team Johnny? I'm team Johnny all day, all day, all day, all day. This man is a good man. He's a good guy. You never really hear any abuse. Like, everybody defends him. His ex-baby, his baby mama, his ex-wife, girlfriends, ex-girlfriends. Okay, everybody's picking Johnny's side because he has a great reputation. And Amber has ruined it. It is what it is.
time, Mr. Depp incorporates by reference the legal analysis set forth in the court's opinion letter dated March 27, 2020, overruling Ms. Heard's demurrer to the 3 defamatory statements at issue. And that letter opinion is attached as Exhibit 1 to Mr. Depp's opposition. That's where the court fulfilled its proper gatekeeping.
Girl, drink all the water you need to drink because you know it's about to get hot. It's gonna about get heated. You're not gonna like what you hear. I know I sound one-sided, but come on. This is Johnny Depp, okay? He is amazing.
Role that Mr. Rottenborn referred to. As a threshold matter, the elements of a defamation claim are the following: publication of an actionable statement with the requisite intent, citing the Shaker versus Bonfault case 290 Virginia 81 at 91. As to damages, they are presumed here because Ms. Heard's false allegations of domestic abuse, sexual assault, and rape constitute defamation per se.
If it was rape, okay, like, all right, let's just say your husband rapes you, okay, and how come you didn't report it? Where is the police report? Where is the evidence? You know, she never has any evidence. Well, she would call the police and then they would be there, and there's no evidence that she's been abused.
Citing the Tronfield case 272 Virginia 709 713, a 2006 case. As the court noted at page 3 of its opinion letter, typically an editorial or op-ed column is ordinarily not actionable because it appears in a place devoted to or in a manner usually thought of as representing personal viewpoints. However, Virginia recognizes that, quote, a defamatory charge may be made by inference.
And if you guys don't know why Johnny is suing Amber, because she did an op-ed saying that he abused her, and he told her, don't try to, ruin my name, because she literally ruined his career. Disney dropped him because of Amber, because Amber said that he abused her. Okay? A lot of people did not want to deal with Johnny at all. And it was all a lie. And it's being proven in court. That's why sometimes it's like, whether you're guilty or you're not guilty, give that person a chance to defend themselves before you drop them, before you just, it's not fair. So now we're going to continue.
Implication or insinuation, citing the Carwell case. And a statement expressing a defamatory meaning may not be apparent on its face, citing Pendleton, with which the court is quite familiar, 290 Virginia at 172. Accordingly, in order to render words defamatory and actionable, it is not necessary that the defamatory charge be...
Sometimes you just got to look at the reaction of like the lady, the Amber's lawyer with the short hair. Don't you think she kind of like, sometimes I look at people's gestures, their reaction, their posture, doesn't look like a very confident woman about this case. And then if you look at the back of the back, I know I'm reaching, but listen, you guys, look at the lady with the black shirt, the big lady, where there's like 2 guys and stuff like that. You can see it in their face that they know they're gonna lose this case. Come on now, they're gonna lose it. Look at how confident Johnny looks. He got one of the best lawyers. Okay, what the hell? Where did Amber get her lawyers from? They're not doing a good job. Johnny's legal team looks very confident. They know what they're talking about. They know what they're saying. And Amber's legal team doesn't look confident. They look like they're wasting your time. That's what I feel. So let's go.
In direct terms, but may be made indirectly, and it matters not how artful or disguised the modes in which the meaning is concealed if it is in fact defamatory. Carwile, 196, Virginia at 7. And based on the authority and reasoning set forth in pages 4 through 8 of the opinion letter, the 3 statements at issue are actionable under a theory of defamation by implication. Mr. Depp established in his case in chief that Ms. Heard, in fact, made all
I gotta say, Johnny Dad, money well spent, because that legal team, I'm telling you, they're amazing. Okay.
3 of the defamatory statements at issue. As the court admitted into evidence as Plaintiff's Exhibit 1, the op-ed Ms. Heard published in her own name in the Washington Post on December 18th, 2018. And let's take the 3 statements and the proof that has been adduced. Statement number 1, Amber Heard, quote, "I spoke up against sexual violence and faced our culture's wrath. That has to change." Per page 6 of the opinion letter,
we're going to pause a little bit. So this is my opinion. When the Me Too movement was happening, and everybody, like a lot of men were getting, pointed out. Let's just say pointed out. They were being exposed. And you know what? The Me Too movement exposed a lot of disgusting men. I ain't gonna lie, they did. But at the same time, this movement literally ruined, let's just say, men that are innocent. Okay? Look at this. She used the Me Too movement for her own gain, for her own, so she can, it's just sick. Like, why would you use the Me Too movement? And you're not a woman that's abused. You're using the Me Too movement because you want clout. You want people to look at you like, oh my gosh, she's the victim. Oh my God, let's support her. Oh my gosh, she's representing for women that are being abused. And it was all a lie. Who does that? That's insane. She's crazy.
the first statement could reasonably convey the alleged defamatory meaning, i.e. that Mr. Depp abused Ms. Heard, to its readers without extending the words beyond their ordinary and common acceptation. See Pendleton, 290, Virginia at 172, also citing the Carwile case. Resolving every fair inference in Mr. Depp's favor, this statement could reasonably imply that the sexual violence Ms. Heard spoke up against was in fact perpetrated by Mr. Depp.
She blackmailed him. She beat him. She degraded him. She talked down to him. She was the worst. Johnny, what the hell were you thinking about being with this crazy lady? What the hell were you thinking? It must have been a low time in Johnny's life. Like, she ruined his life. Okay.
Mr. Depp produced several credible witnesses and documents proving that Ms. Heard was implying that he committed sexual violence against her. Mm-hmm. Mr. Depp himself testified to that, as did his sister, Christy Dombrowski. Mr. Depp's former agent, Christian Carino, testified that, as did his current agent, Jack Wiggum. But perhaps most convincing of all, and most disgusting of all, was the testimony of the ACLU's Terrence Doherty, a lawyer nonetheless. Mr. Doherty testified, among other things, that when when they were pitching the op-ed to the Washington Post, they stated, "Hey, Michael, wondering if we might interest you in a piece by Amber Heard, who, as you may recall, was beaten up during her brief marriage to Johnny Depp, on what the incoming Congress can do to help protect women in similar situations."
She used a very important cause for her own gain, so she can blackmail Johnny. It's like, I just want to say this, even men can be abused, okay? Not just women. Men can be abused as well. And this is like, to me, it's like, this is something that is so public that it has to be seen. There are some conniving women out there that would use that and destroy a man. You know what I'm saying? So, and it's just like really disgusting to use real life pain and what women go through, but she used it for her own so she can make money, so she can blackmail the man. It's like she is sick. I think I said that enough. Sorry.
Mr. Doherty also testified that everybody understood, as Ms. Heard and the ACLU clearly intended, that this statement and the other two statements referred directly to Mr. Depp. Quote, "This is an article that was in USA Today and specifically ties Amber's statement in her op-ed piece to Johnny Depp." And when Jessica White, who actually wrote the op-ed that Ms. Heard later adopted, she says, quote, to Mr. Doherty, "So much for not mentioning JD," when the USA Today made clear that they, like everybody else who read the op-ed, understood that, as Ms. Heard clearly intended, it referred to Mr. Depp.
Not only that she is proven a liar, but she used to date someone. No, she was married to a woman. And she used to beat that woman too. She even went to jail. So patterns continue. So if you want to be in a relationship with Miss Amber Heard, be prepared to get your ass whooped. Okay? All right. I'm going to say allegedly for now.
Which makes her Instagram post 2 days before the trial began, that she didn't mention Mr. Depp, all the more outrageous. Your Honor, there is Ms. Schulman, also of the ACLU, acknowledged that Ms. Heard's op-ed referred to Mr. Depp. So it's very clear that the ACLU and Ms. Heard intended, that was the whole purpose of this, so that they could get interest in this and it would coincide with the premiere of Aquaman, because otherwise no one would have been interested in anything written by Ms. Heard.
And let me tell you something, you guys. This is going to be the death of Amber Heard's career. She ruined this man's career. Now it's her turn to get her career ruined. Amber was going to pay for everything that she's done to Johnny, because you don't get away with hurting someone. Even if you don't get like karma right now, just know karma's gonna come.
Authority also testified that Ms. Heard only paid 1.3, actually she didn't even pay all that, out of the $3.5 million that she had pledged to the ACLU, and then they helped her lie about it. And it's one thing, Your Honor, for her to stiff the...
So what he's talking about is that Johnny gave her, because she requested it, she asked Johnny to give her $7 million. I think she gave like 100,000, and then he said $1 million or whatever. But she said she was gonna give the whole money to charity, and she did not do that. Johnny wanted to pay on her behalf directly to the charities, and she said no. And she wanted it tax-free. You see what I'm saying?
ACLU, which frankly played a reprehensible role in this case. It's quite another for her to fail to honor her obligation to the Children's Hospital of Los Angeles with sick and dying children. And that she failed to do as well. And as Your Honor has mentioned, the fact that she put her name on that article means that she is responsible for...
And the other thing, Amber has a kid. I just pray that one day when that child is older, that she's going to be safe. I really pray.
All of those statements, which she specifically adopted later. And I'll go through the other two statements quickly, Your Honor.
Well, can we stay on this one for one moment, though?
Yes, Your Honor.
Because do you agree that the only evidence before that we've heard in this trial, as far as the title of the op-ed, is that even Mr. Doherty, I believe, testified to it, that it was something that Washington Post wrote?
Well,
for the one online.
He's not our witness, Your Honor. That's a witness from the ACLU.
Well, I understand, but it's the only evidence I have.
I respectfully disagree.
He said he's. I think he's gonna say I respectively disagree. So, I just gotta tell you, Judge, please judge right.
Agree, Your Honor.
All right.
What the only real evidence Your Honor has is Plaintiff's Exhibit 1, which is Amber Heard putting her name on the entire article, including the title. That is the only evidence before you. The ACLU was a co-conspirator with Ms. Heard, and whether they say, oh, maybe the Washington Post wrote it, that's not the
Yeah, and he said what he said.
end of the story. All she has done is create an issue of fact as to whether she wrote the title or not.
So you're saying just having that exhibit in evidence is enough?
Absolutely, Your Honor. Her name is on the article.
Yep.
What does an average reader expect? So that alone is sufficient to beat a motion to strike. If they want to come back later and say, gee, she didn't write the title, as if that were a defense, I hope they...
And you cannot fast forward, rewind. You can't do nothing. Once you have wrote it and it's on public knowledge, it's over. So I agree with this attorney. It's over.
They make that argument. I hope they make that argument to the jury, because it's about as credible as her argument that, oh, I wasn't referring to Johnny Depp. She didn't have to. And the testimony of Terrence Doherty was very clear that when they took out the references to Johnny Depp, no.
You know, I want an attorney that would go all hood for me. You know what I'm saying? Like that attorney, you can tell he's like, he want all the smoke.
No one was interested in this article anymore. So she said, put it back in, make it more spicy so people would read. Otherwise, she couldn't get it in the Washington Post. It would be back in Teenage Vogue, which is the other publication that was considering publishing it, because no one was interested in what she had to say, unless she was defaming Mr. Depp. But if I could go to the second statement, I'll try to be quick, Your Honor. 2 years ago, I became a public figure representing domestic abuse, and
Amber is not a victim. She is the abuser. Okay?
felt the full force of our culture's wrath for women who speak out. As for the second statement, defendant called herself a public figure representing domestic abuse, which can be read to imply
correction is public faker. Trying to represent for women as being abused. And now, I've heard that she's on the United Nations because of this. I was like, oh my God, this is so disgusting.
that she became a representative of domestic abuse because she was abused by Mr. Depp, not just because she spoke out against alleged abuse. This inference can be drawn without extending the language beyond its ordinary common acceptation, citing Carlisle 196, Virginia at 8. Your Honor, quote, to constitute a publication, it is not necessary that the contents of the writing should be made known to the public.
Okay.
Generally, it is enough, it is said, if they are made known to a single person, unquote, citing Snyder versus Fatherly, 158, Virginia, 335 at 350. Everybody and his grandmother testified that Ms. Heard was referring to her bogus ex parte TRO that she obtained on May 27, 2016. And it was interesting that Mr. Depp's own lawyer said that she wasn't even provided notice. So Ms. Heard made very sure that Mr. Depp wouldn't have notice of the ex parte TRO. And Ms. Heard herself, the evidence shows, knew.
You see how like the attorneys on Amber Heard's side, they're like, oh no, like, you know, what is he talking about? Stuff like that. He's lying. The proof is in the pudding, okay?
That Mr. Depp, having just suffered the loss of his mother, was already on the other side of the country, was already...
And allegedly, when he lost his mom, she was cheating on him.
in New York at the time of this TRO and was heading to Europe for several weeks. So she knew she didn't need any protection from him.
Right.
This was just a scam for her to get the $7 million in the divorce settlement that she said she gave to the ACLU. She swore she gave to the ACLU and the Children's Hospital of Los Angeles, and she pocketed instead.
that, yes, she sure did. Because they brought the person that's like in charge of the ACLU, and he told the truth, and it was embarrassing. Oh my God. Anyways.
Mr. Depp, Ms. Dombrowski, Mr. Carino, Mr. Wiggum, and the inimitable Mr.
You know what I think when Amber's doing when she does that look and stuff like that, she's trying to intimidate him. But let me tell you something, sweetie. This man, you can't intimidate at all. I don't think so.
Mr. Doherty of the ACLU, which lent its once respected name to Ms. Heard's defamation. So while Ms. Heard may have avoided any direct mention of Mr. Depp's name, there is extensive testimony and evidence in the record showing that the implication of her op-ed could not be more clear.
I don't know why she does this like this look. It's really annoying. So weird.
i.e., that Mr. Depp abused Ms. Heard during the course of their marriage. Under Virginia law, quote, it is not necessary that the defamatory charge be in direct terms, but it may be made indirectly. And it matters not how artful or disguised the modes in which the meaning is concealed if it is in fact defamatory. Citing Carwile, well, we can argue as to how artful it was, but the implication was very clear, as the court has previously ruled, or not law of the case, but as the court has persuasively written in its opinion letter. Let's move to the falsity of Ms. Heard's ever-evolving and ever-escalating.
And, oh gosh, and my daughter. If she cries one more time, I'm going to have to do a part 2. Okay. We're just going to go on with the video.
Change of IPV and sexual assault. Mr. Depp's sworn denial is all he needs to survive a motion to strike. But there's a lot more than that, Your Honor, and I'll try to be brief. 3 police officers, actually 4, but the 3 who testified already, Officers Sines, Haddon, and Gatlin, testified unequivocally that Ms. Heard did not have a mark on her.
What? Shall we hear it again? So petty. Shall we hear it again?
Than that, Your Honor, and I'll try to be brief. 3 police officers, actually 4, but the 3 who testified already, Officers Sines, Haddon, and Gatlin, testified unequivocally that Ms. Heard did not have a mark on her on the evening of May 21, 2016.
Okay.
And I could go through, I'll just go through very quickly. Officer Haddon, strike that. Officer Melissa Sines on jury trial day 10. Question, did you provide a copy of this pamphlet to Amber Heard? Answer, I did not. I didn't identify her as a victim of domestic abuse. The next day, Officer Melissa Sines. Okay, at this time, did you notice any injuries on Ms. Heard? Officer Sines, I did not.
Wait, I really got to do like the reaction, like the way she does her. Why does she do her face like that? It's just very bizarre. She's trying to look innocent. It just looks weird.
Question, okay, were you looking to see if she had any injuries on her at the time? Officer Sines, yes, I was. Question, and so you were looking to see if Ms. Heard had any injuries and you determined that she did not. Is that accurate? Officer Sines, correct. Question, okay, and was the lighting good enough in the hallway?
And when you have evidence, they take pictures, they take you to the hospital, they clean you up, they whatever you got to get sutures or whatever, or band-aids or whatever they have to do. And there's no evidence, like the police could not collect evidence. If the police cannot collect evidence, that means you never got abused. Anyways.
For you to make that determination, answer, yes, the hallway was well lit. Officer Gatlin's testimony was the same, and he had the body cam.
And he had a body cam, and his words never changed, and he kept saying the same thing, and they kept asking him the same questions.
Officer Haddon's testimony was the same. The testimony of nurses Debbie Lloyd
Okay, Amber, you know you're guilty, but continue.
and Aaron Barham, who, like the police officers, did not work for Mr. Depp. In fact, they worked for Dr. Kipper, also belied Ms. Heard's false allegations of abuse. Isaac Baruch and Alejandro Romero both testified that they saw Ms. Heard repeatedly and in the clear light between May 21.
I love the fact that this attorney looks her dead in the face and it's like, yeah.
2021, which was the last time Mr. Depp saw her before leaving on the Hollywood Vampires tour. The next time he was to see her was when Ms. Heard begged him to come see her in San Francisco, which is hardly the act of a domestic abuse victim.
If someone is abusing you, why the hell would you go back to get abused again? What?
So we have Isaac Baruch and Mr. Romero saying that they saw Ms. Heard repeatedly in the interval of time between May 21 and May 27th, when she obtained the farce ex parte TRO, and they saw no marks on her face and no swelling.
The stories never change. The evidence, there were no evidence. The stories stays the same. If a woman like Amber was being abused, it would be noticed. It would be documented. It would be like there would be images. But niente, nothing.
Two witnesses, Mr. Baruch and Brandon Patterson, saw the video of Ms. Heard and her sister Whitney pantomiming the fake punch after this alleged incident of abuse. Ms. Heard's former personal assistant, Kate James, and several other witnesses, including Dr. David Kipper, saw no violence by Mr. Depp.
Saw no violence. No violence. No nothing. Nothing. Zero. We will continue the video.
And no injuries to Ms. Heard. Indeed, witness after witness has come forward to testify that Ms. Heard, far from being a domestic figure representing domestic violence, unquote, is in fact a recidivist perpetrator of domestic violence on Mr. Depp and others. We have the testimony, the harrowing testimony of.
It must be very excruciating defending someone that lies a lot and that doesn't have receipts. Like, it's bogus. I feel sorry for her lawyers. Like, I would quit. I would have quit. If I were an attorney for Amber, I would have quit because where is the receipts? Don't waste my time.
Mr. Depp himself, who described several witnesses. One, as Your Honor will recall, when he was hiding in the bathroom after escaping one of her attacks, and she claims to have hurt her foot kicking the door. Mr. Depp opens the door to see if she's hurt, and then she kicks the door in on him and punches him.
Oh my God. Can you imagine? Can you imagine? You know, Johnny came from, his mother used to abuse him. I feel like this literally is a life lesson for Johnny not to ever take crazy hoes or never let anybody abuse him. You know what I'm saying?
The incident of December 15, 2015, when Ms. Heard threw punches at him wildly at the back and side of his head.
I'm so confused. Why do you need glasses to write words? And you cannot, like this, she's so delusional, you cannot intimidate him by just like staring at him. It's kind of weird. I would have been like this. You know,
Mr. Depp testified that he ducked and covered to protect his face. Eventually, he turned around to grab her and stop her arms from flailing. December 15 in the Bahamas. During an argument, Ms. Heard grabbed a can of mineral spirits and threw it at Mr. Depp's face, striking him in the forehead, bridge, and nose area, and the jury saw a photograph of the bridge on the bruise of his nose.
right.
We have testimony from Mr. And by the way, Tara Roberts, who is the manager of the island.
Her own assistant couldn't even defend her. It's hilarious.
Confirmed that the incident with the mineral spirits. You have Mr. Depp's testimony of what happened on April
What's
20th.
a mineral spirit? I have no idea what the hell that is. Mineral spirit? Mineral spirit. Don't tell me it's that big gallon of water. She threw something like that on his face? Oh, Johnny, you was with a lunatic.
2nd, 2016. And we've heard testimony today from Aaron Borum-Filati that Mr. Depp was very responsive, was very sociable,
Right.
was not in any way inebriated that day when Ms. Heard says he was, and she attacked him that night as well. And I'm getting to the end of this, Your Honor. We have Ms. Heard's own admissions. We have her.
It's like
admitting,
it's kind of hard. It's kind of hard. I'm sorry. It's kind of hard to defend someone that that has no evidence, and then she's incriminating herself. You know what? I feel like there should be a bill of people who lie. I should go to jail and face the consequences.
To hitting Mr. Depp, and her only contention was that she wasn't punching him, she was just hitting him.
Still,
We have testimony from Travis McGivern that on February 23rd, 2015, Ms. Heard threw and hit Mr. Depp with a can of Red Bull, and then sucker punched him with a closed fist.
okay. I don't know how Johnny kept dealing with this BS. This is disgusting. She threw a Red Bull on his face and sucker punched him. What? This lady has some anger issues. She needs to take anger management. She needs to go to jail. She needs to go to jail for at least a year because they won't keep her that long.
Finally, we have the rather stunning testimony of Ben King, quite a credible witness who accompanied Ms. Heard on the flight back from Australia, where Ms. Heard admits to him in a rhetorical question, quote, "Did you ever totally lose it on someone you love?" Which was, we would respectfully submit, an admission of her severing the top or the tip of Mr. Depp's finger.
She threw a glass bottle at him the first time, and then the second time, I think, I don't know, maybe second or third, threw it another bottle, and the bottle cut his finger. Like, it was bad. He had to get surgery.
Finally, Your Honor, statement number 3, quote, "I had the rare vantage point of seeing in real time how institutions protect men accused of abuse." Again, quoting very briefly from page 7 of the court's opinion letter, quote, "Drawing every fair inference in plaintiff's favor, the court can fairly conclude that defendant's statement that she saw how institutions protect men accused of abuse could reasonably convey to its recipients that she saw how Mr. Depp was protected by institutions.
Next time I'll break down the videos, but sometimes I'm gonna have to do like hour, like, because I see like the videos are like 1 hour long, so I'm gonna have to like have coffee because I'm trying to stay awake.
That he abused her and spoke up against it. Your Honor, again, we have multiple testimony from multiple people, including Jack Wiggum and all the others mentioned, that this was a reference to that. Your Honor, again, the lies that have already been exposed that Ms. Heard has told about the
Sorry, you guys, I'm falling asleep.
charitable contributions, the incidents in this case, and again, I'll just cite a couple of more. The testimony of Isaac Baruch when...
Uh-oh, what happened? Yeah, just like pause. Did I do something wrong? Oh crap. The video just paused. I don't know what's going on.
When...
See if I can like... I don't know what's going on. I'm sorry about this. It just like literally stopped working.
Testimony, Douglas Banyan.
Just gonna...
So we had Ms.
Okay, so it was not me. It was literally like, there was a problem.
We've had the testimony, so we had Mr. Wiggum testifying as to the 22.5 lost on Pirate 6 and another 20 lost on the other films, the other studio films, the indie films, and the other ways Mr. Depp would have made income. We have Richard Marx's testimony, Douglas Banyan's testimony, and the testimony of Michael Spindler just this morning. Mm-hmm. Finally, Your Honor, none of Ms. Heard's affirmative defenses, which would include, her trying to create an issue of fact on the title, can support a motion to strike, as to which she bears the burden of proof of her affirmative defenses. Quote, whether the defendants have met their burden cannot be resolved when considering a motion to strike. See 243 Virginia at 83. And just to...
Boys, them attorneys are tired because they realize that they are being, like, their time is being wasted, but I hope she pays them.
To respond to Mr. Rottenborn's citation to the Lakova case, which we hadn't seen until he mentioned it today, I would only note, Your Honor, that defendant admits that she tweeted a link to the online version of the op-ed at paragraph 97 of her answer, though again, the admission of Exhibit 1 is more than enough to survive the motion to strike. And the Lakova case at 995 F3rd 134 holds that republishing a hyperlink doesn't necessarily start the statute of limitations, not that a hyperlink cannot be defamatory. So with that, Your Honor, we respectfully request that the court deny the motion to strike in full, and let's hear from Ms. Heard. Thank you, Your Honor.
Yes, sir. Thank you. Your motion.
Thank you, Your Honor.
So here you go. You guys got it. I hope you like my, I was a little dramatic. So next time I promise that it's going to be better. And if you guys have any comments, please like and share this video. And I don't know, tell me what you guys think in the comment below, and please subscribe to my channel. I would much appreciate it. And I'm going to do more Johnny Depp trial, and I hope I don't get flagged. I'm sorry. I'm Team Johnny, period. Because I remember when this thing first started, when she was accusing him, I never believed it because I've never heard Johnny Depp abuse women ever. So he was literally like, people were seeing him as guilty before being innocent. Anyways, I feel like this is gonna ruin Amber Heard's career, and Johnny is finally gonna be seen as an innocent man. So, congrats in advance, because I feel like he will win. Yes. Okay, you guys don't forget to subscribe if you like this video, and I'll see you next time. I'll see you tomorrow. I'll do another video. Peace. Peace.